In the next edition of It's About Money, my guest is Phil Burke. He is an estate planning attorney, and we'll be talking about the changes in the New York State estate law. Look forward to having you watch our show. Hello and welcome to another edition of It's About Money. I'm Nannette Nocon and thank you for joining us. I'm excited to have Phil Burke as our guest today. He's been an estate planning attorney in our community for the last 30-some years. Known you for almost that much time.
Almost.
So let's talk about this big change in New York State estate tax law that came into effect April 1st of 2014. But before we go to that, many people always ask, I just got this inheritance, what tax do I pay? So what's my inheritance tax?
Well, there's two taxes that people are concerned with, whether or not they have to pay income tax on what they've received from an estate. And most of the time, inheritances are not income taxable. So if Uncle Joe dies and leaves you $1 million, you don't have to pay income tax on that money, unless it's an IRA, which is all taxable and depending on how you take it out over time, or an annuity, which has deferred income built in. So if you're the beneficiary of an IRA or an annuity, there probably will be some income tax ramifications that you have to deal with. But on a straight inheritance, cash, piece of real estate, an investment account, you don't pay tax on the asset you've received. You pay tax, obviously, on the dividends and interest that it earns, but not on the inheritance itself.
Okay, it's very important to share that because many people are concerned about, oh my gosh, what's my inheritance tax? But New York doesn't have an inheritance tax for the recipient.
They don't have an income tax, yeah. And there's a difference between an estate tax and an inheritance tax. When somebody's estate is subject to tax, which we'll be talking about, the estate pays the tax before distributing the assets. Some states have what's called an inheritance tax, where the recipients pay the tax on the inheritance. Not an income tax, but almost like an estate tax, just who pays it.
Okay, so some of our bordering states have that, right?
Yeah, so, Pennsylvania, for example.
Okay, so let's talk about the estate tax. There's a new change that happened on April 1st, 2014, but prior to that, it had been the limitation of how much we can die was quite restrictive, so without being taxed, I mean.
Right.
So help our viewers understand that.
Well, there's two institutions we have to deal with, the federal government and New York State. For the last couple of years, the federal estate tax exemption has been in excess of $5 million per person. Most people do not have $5 million. It's almost literally the 1% type of situation. So most people do not have any federal estate taxes to worry about. Up until April 1st, the New York exemption was only $1 million. So that if someone died in New York and they had more than $1 million, there was the potential that their estate would be subject to the payment of New York estate tax, depending on who the beneficiary was, which we can talk about in a moment. As of April 1st, New York increased that exemption to slightly more than $2 million. They doubled, for all intents and purposes, the amount of assets that New Yorkers can leave to somebody besides a spouse or charity, free of any estate tax. That exemption is scheduled to increase next April to slightly more than $3 million, April of 2016 to slightly more than $4 million, and by January 1 of 2019, New York should be in line with the federal exemption, which again is over $5 million.
Great. So it makes it more attractive for someone with significant or some wealth to stay in New York and die in New York. I mean, I hope they live a long life, but in terms of estate planning, So basically, there's a little bit more flexibility for individuals with estates greater than $1 million.
Right, and fewer New Yorkers have to worry about any New York or federal estate taxes.
And so that came into effect April 1st. Like you said, it's a little bit over $2 million now. But you did say an exception to that, $2 million, and that is the spousal beneficiary and also the charity.
Right.
Let's talk about that for a minute.
Anybody can leave their assets to a surviving spouse free of any estate tax. I often say that someone has $1 billion, they can leave it to their spouse completely free of tax. The tax man comes when the survivor dies and the money funnels down to the next generation. Also, anything that's left to charity is completely free of estate tax. So For example, if no one has any real close relatives, nieces, nephews, etc., they can leave some money to those individuals and then leave the balance to charity and still pay no tax. So using this marital deduction, what you're leaving to your spouse, and charitable deductions can often significantly reduce or at least forestall the payment of estate tax.
Got it. Okay, so there's something to think about if charity is part of someone's
Part of the planning.
plan.
Yeah.
Yeah. Okay, that's great. And then someone, of course, who's not married would have the issue of leaving assets to a non-spousal beneficiary.
Right. And but
causing
now
the
they've got that
possible
$2 million
tax.
limit for New York purposes.
Okay, great. So with these big changes, what are the implications you think for individuals who've done some planning prior to April 1st of 2014?
Well, a lot of people planned their estates to avoid or reduce the New York estate tax by using trusts and different types of planning vehicles that were commonly done for people that had taxable estates. Those estates may not be taxable anymore. So what we call a simple plan or a simple will, leaving everything to a spouse or everything to children without the use of trusts, may be more advantageous, simpler obviously. However, there's other reasons to use trusts. Protecting assets from long-term care, nursing home expenses, protecting assets from creditors. Somebody, goes out and hits somebody with a car and gets sued. Assets that they own are potentially subject to claims of that creditor. If they're in a trust that is held for that for the benefit of that person, the creditors probably cannot, under most circumstances, get access to those funds. If somebody really can't handle money, or they've got, God forbid, a drug or alcohol or abuse problem, you may want to use a trust for other reasons other than tax avoidance.
Okay, great. So it's really important to meet with their estate planning with an estate planning attorney to take a look at whether or not the wills that they had done prior to April 1st are still current.
Correct.
Yeah. Okay.
I just to put a footnote on that, if they have those issues, someone that can't handle money, someone who's got an addiction problem, they probably already have those in place, I would assume. So if they didn't have any estate tax issues to begin with, they were below the old $1 million exemption and clearly below the new $2 million, they may not need to run back to their attorney and say, what do we got to do? They may have everything already in place.
Okay, but if they have those issues and they haven't thought about other strategies,
Correct.
Then they need to think about that because it could disqualify somebody from getting benefits from the state. And things
Government
like that,
benefits,
right?
things of that nature, right.
Yeah, okay, great. Regardless, it's probably good to review the will
Absolutely.
and all that. So, and it comes with that, I always tell clients, make sure you review your wills with your attorney and the power of attorneys and healthcare proxy. I'm going to take a pause for a second because there was also a change with power of attorney documents a few years ago, right? Would you talk about that?
Back in 2009, 2010, the state legislature changed the power of attorney form. Existing powers of attorney that were executed prior to that time are still valid. They do not need to be updated. If they're 10, 15, 20 years old, they probably should be updated just out of a good practice, but existing ones are still valid. What happened was there was a situation downstate where someone stole money from his uncle using a power of attorney, a lot of litigation, et cetera, and the legislature got wind of it and they said, we really have to protect primarily senior citizens who may be taken advantage of by someone getting a power of attorney and stealing all their money. So there's a new form. And this is the New York statutory short form that's now 9 pages long.
I know, I always think that's
and
comical.
the major change involves gifting. It is very common for someone to appoint their agent under a power of attorney and give that agent the right to make gifts. The purpose of that gift is to reduce their estate for estate tax purposes, or maybe to transfer assets to protect assets from long-term care expenses, etc. But now the new gifting power is intended to maybe raise the awareness of the person who's signing the power of attorney and say, hey, I'm giving my sibling, my child, my niece or nephew the right to really take all my money and go to Vegas and spend it. So I'm going to think twice about it and I'm going to make sure that the person I'm giving this authority to is trustworthy. So it's kind of a consumer protection type of legislation, but it does make the planning with the power of attorney a little more complicated.
So the person you're assigning as power of attorney needs to be aware, at least acknowledge that they are.
Yeah, the new law does also say that the agent, the person that you're appointing, also has to sign the form indicating they're willing to act. And there are instructions and warnings to the agent, saying if you sign this, you're signing up for you're a fiduciary. You have obligations. You just can't take the money and run.
You just can't go have a shopping day.
Right.
Well, I think that's really important. So a lot more of our population gets older and requiring some assistance. I think that's very good, but it is a little bit interesting how the short form is rather long.
Exactly.
So, but important to point out that existing power of attorneys still are valid, right?
Correct.
Because I think at some point there was an issue about, gee, you need to provide the institution, the financial institution, a more recent power of attorney, but if it's already being used, and the person who had granted the power of attorney can't sign, how can they possibly update the form? It's like, oh, this is
a little bit of a conundrum, but most of usually the banks that had a problem way back when we first started, the banks wouldn't take a New York power of attorney. They wanted their own form. And fortunately, the legislature and cooler heads prevailed, and now they most of the time will take a power of attorney as long as it's valid and signed, et cetera.
Yeah, great, thank you. Do all estates file a tax return?
An estate tax return, no. You only have to file an estate tax return, which is due 9 months after death. You can get extensions if you have to. If your estate exceeds that exemption amount. So if someone dies after April 1st, 2014 and a New York resident, if their assets exceed that $2,065,000 exemption amount, they're supposed to file a New York estate tax return, even if there's no tax due. If I leave everything to my wife and it's all covered by that marital deduction that we talked about and there's no tax, if I've got a $20 million estate, it really makes no difference to the state whether I file it or not because there's no tax. But the state still says you have to file the return. There's no penalty, there's no interest for failure to file because those interests and penalties are based on the amount of tax owed. If there's no tax owed, there's no penalties or interest. But the state's position is that they want to know what's there so that when the survivor dies and the survivor's tax return shows up with $2 million instead of $20 million, they're going to want to know what happened to the other 18 and look into whether or not there was some gifting or tax fraud or whatever.
Sure.
It's more informational than for any other reason. But if your estate is less than that exemption amount, you don't have to file.
And that's New York. And is that the case for federal as well?
Same case for federal, yeah. Right. Now the one difference between the federal and the New York is something called portability. The federal exemption, as I said, is $5.3 million. The New York exemption is $2 million. If I leave my $5.3 million estate to my wife, there's no tax. Under federal law, she gets my $5.3 million exemption as well. So her exemption is now 10.6. In order for that to transfer or to become portable, you have to file an estate tax return and make that election. New York does not have the portability as part of its law. We're hoping they change that. But so if I have a large estate and I don't use all of my exemption, I'm going to want to leave that exemption to my spouse. So I'm going to have to file a return listing all my assets and everything else for the purpose of getting that exemption ported? That's the right word, transferred over to my spouse so that she can use it when she passes away.
Great, because that's new, right? That's never been.
That's just in the last year or two, right?
Yeah, I think that's
years,
phenomenal. Right? But very important, like you said, to file an estate tax return. Otherwise, you lose it.
Yeah,
yes.
exactly.
Great. We'll take a quick break, and
okay.
we'll be back. We'll be right back. I'm Nannette Nocon, and this is It's About Money.
So good to see you guys. So, what's up?
Oh, we finally bought a place.
Holy cow.
You seriously have enough saved to do that?
We've been putting a little aside each month.
Jeez, at the end of the month, we have nothing left to save.
Yeah, I have no idea where it goes.
Well, you're spending a lot on...
Is it good?
Oh, God.
Oh, how is my account overdrawn?
When it comes to financial stability, don't get left behind. Get tools and tips for saving at feedthepig.org.
And we're back. My guest is Phil Burke, and he's an estate attorney at Woods Oviatt in Rochester, New York. And we're talking about the changes in the New York State estate tax law as of April 1st, 2014. Thanks again for joining me.
You're welcome. Thank you.
So we talked about the changes in terms of how much an individual can pass away without having to pay estate taxes. And we also talked about the federal, which has the portability and
Right.
filing a tax return for that, a gift tax, estate tax return for that. What are the, why do you think it's important for an individual to look at their estate and put a will together? And why is that important?
Well, there's lots of reasons for people to plan. If you don't have a will, New York State directs where your individually owned assets will pass. A lot of people don't recognize the fact that assets like joint bank accounts, a joint home, life insurance paid to a named beneficiary, retirement accounts paid to a named beneficiary, those pass automatically to the survivor or to the beneficiary who's named. So if I pass away and my house is joint with my wife, my bank account is joint with my wife, my insurance is paid to my wife, and my will leaves everything to my kids don't get anything because the ownership directs that the assets pass to my wife. So people's will only controls things in their name alone. If you have assets in your name alone, those are the so-called probate assets, and you don't have a will, New York law directs where those assets will pass. And if, depending on the amounts, there are some adjustments for different values, assets will pass to spouse and to children. If you have minor children, 10, 12, 2, 3 years of age, those assets are going to have to be held by a guardian until that child reaches 18. At 18, the funds belong to those children. And I always tell clients 4 years later they have a 4-year-old portion, no college education. So part of the plan is if you have young children, or you have, as I mentioned earlier, individuals that can't handle money for whatever reason, you want to make sure that those assets are held for their benefit in a trust with a family member or a friend or a bank or an institution as trustee to handle the money for that child and pay it out when the parents feel they're old enough, 25, 30, 50, or if they have a disability, maybe it's held for lifetime, and when that person dies, paid out to other beneficiaries. So planning really is not just about taxes, it's about the practical side of things. Who's going to get the money? How are they going to be able to control it? How are they going to be able to spend it? And who's going to influence them in how that money is going to be used? And as you mentioned earlier, there's also lifetime planning, a power of attorney if you become incapacitated, a health care proxy for medical decisions. So there's more to the plan than just looking at the tax dollars.
Sure, sure. Yeah, because you want to make sure that whatever it is you want to have happen, happens, right?
And also, if I may, appointing a guardian for minor children, making sure that that if you and your spouse pass away or the survivor passes away and you have young children, you appoint the person that you want to raise those children as opposed to potentially a court appointing someone. And you have to recognize too that this is just a nomination. Ultimately the court does decide if the person you named is the right person. And if they're not, someone else could be named. But 99.9 times out of 100, the court's going to recognize the person that you nominate as being the guardian for your children.
I suppose if someone's in jail or something like that.
Yeah, there are situations where unusual circumstances do kind of dictate that maybe we have to go someplace else, right?
No, so actually, if there was no will, would the court ever appoint to break up the children? Has that ever happened? Like if you don't appoint a guardian, would they ever do that?
Not in my experience.
Okay.
You may, and again, you're an adult at 18, so by and large, family members would step up and take the children, and if there's 10 kids, maybe someone can. But I've not had any personal experience with child A going to grandma here and child B going to aunt there, et cetera.
Sure, sure. But then you want your children to be left to the guardians that you would want to take care of the kids, because you might know that better than probably know it better than the courts would, right?
Right. Yeah, and the important thing is you want to name individuals that are going to raise your children the way you want them to be raised. A lot of people, especially if their parents are older, they say, well, I'm going to name my parents. Well, that's all well and good and fine, but think about it. Your parents are 70, your children are 6. What's going to happen in the next 10 years? Are they going to be healthy enough to take care of these children? Do they have the same basic, ideas of how to raise children that you do? And I'm not there to tell them they should or shouldn't appoint someone, but just to think about it some more.
Sure, sure. If they do, they probably should think of of a successor, right?
Correct, yeah,
Just
as
in
a
case.
backup. Mhm.
Yeah, it's just life expectancy doesn't do it. You know, some of the times I encounter people say, yeah, I'm leaving this money to this child, and I've instructed them to divide it up among other children.
Mhm.
And I sort of look at them and say, do you really want the child to have the burden of doing what you've given them and be conflicted? Because legally it's theirs, right? If
Correct.
they name that one person.
Especially
outside of the will.
with if you have a disabled child, it was very common years ago to say, I'm leaving assets to my non-disabled child or children with instructions to use those funds to take care of their disabled sibling. The problem with that is if it works, fine, but if it doesn't work, the non-disabled child passes away prematurely. Those assets pass under that child's estate to maybe a spouse, other children, and those funds are not going to be available. Or that other child gets into a car accident and gets sued, and those assets disappear to a creditor. So you can now set up supplemental needs trusts to benefit disabled individuals, and they won't lose their government benefits. So there are a lot of other plans that you can put into place rather than, as you said, putting the burden on the other children to say yes or no, I'm going to buy you a new car, or I'm going to pay for the roof on your house, or I'm going to pay your health insurance premiums.
Sure.
And not take the money themselves.
Sure, because the conflict. What if they need the money for their own children's education, but that wasn't the purpose of it? You know what I mean? So I just try to remind them, don't give your child that conflict, because that's a very difficult decision to make.
And it can very often strain the relationship between, you know, why did mom and dad give you my money and you're telling me no? You know, who are you?
Right. I've seen that happen so many times, even with the modest amount of money, and it's rather sad because you'd want the family to stay together, but actually the money can break it up, which is unfortunate. So what actually what do you think, going back to our original issue of the New York State tax law change, what prompted the state to kind of say, okay, we're going to match up to the federal government by 2019?
I think the powers that be in Albany finally realized that with a $5 million federal exemption and the old $1 million New York exemption, that $4 million difference was enough for wealthier people to leave the state, to go to a jurisdiction like Florida or some other jurisdiction that has no estate tax. And so the state was, I'm assuming, losing revenue. They're losing estate tax revenue, they're losing income tax revenue. People aren't living here, so they're not paying sales tax, they're not paying, gasoline taxes, use taxes, et cetera, et cetera. We're such a great state for tax. That I think the numbers finally got over to the point where they're saying we have to do something to keep people from migrating out of the state. We had tried to get the state, through the State Bar Association, to change this years ago, but the numbers weren't there. The numbers were always in their favor. We have more estate tax revenue, we have more income tax revenue. When you can show us those numbers are changing, we'll think about changing the estate tax, and I think that might have happened.
Finally happened, right? You have Golisano moving to Florida.
Yeah, the paper
sure
reported he's saving $13,000 a day or something like that in taxes. Nice problem to have.
Yeah, that's right. And if you can keep them as New York State residents, they could pay income tax while they're here, as opposed to...
And they're paying sales taxes, and like I said, you're losing not just the estate tax, but income taxes and everything else.
Sure, and property tax. So in terms of wills, power of attorney, and the last one, healthcare proxy, that I always talk to clients about, important to have healthcare proxy in place too, would you say?
Yeah, healthcare proxy is a document that says if you cannot make your own medical decisions for whatever reason, you give someone else the authority to make those decisions. And it may be as simple as consenting to surgery, consenting to chemotherapy, consenting to, any medical procedure. If you have the ability to make those decisions, even if you can blink once for yes and twice for no, you can decide as long as you're competent. If you don't, then to some extent you're at the mercy of the powers that be as to who's going to decide what treatments you get or don't get. And there can be a lot of friction in families as to whether or not mom is going to get more chemo, or let her go, she doesn't need it anymore, or mom's going to get the surgery, or she can't handle it. And the healthcare proxy gives the agent that's named the right to make those decisions. The next level, though, is that you can give the proxy, the agent, the right to make end-of-life decisions. Excuse the expression, pull the plug. That right does not vest until 2 doctors have certified that the person has reached that stage where there's no chance of recovery, a persistent vegetative state, all those buzzwords that you've heard before. Most people, in my experience, don't want to be hooked up to ventilators and breathing machines and feeding tubes, et cetera. Some do. It's a personal choice, but you can make the choice. And New York now, and most states do allow you to make that decision and have a proxy that lists what your wishes are.
So if something like that happens and you're not in New York State, do they the other states honor the healthcare proxy?
By and large, yes. Most states, to my knowledge, have, it might be what's called a healthcare power of attorney. It might be a living will. It, they may call it something differently, but most states will honor a proxy or some type of healthcare directive that was executed in another jurisdiction, as long as it was executed properly. And I hate to put this in economic terms, but a lot of the issues, I shouldn't say a lot, some of the issues involve with the hospital or facility saying, we've got someone here who's getting terminal care. It's costing us a lot of money, and we're not getting anything from the insurance company or from the family because they can't afford it or whatever. And not that they're encouraging people to make end-of-life decisions. They're not discouraging it because they can get someone else into that bed that is covered by insurance or what have you. I don't mean to be flip about that or that callous, but I think that does come into the conversation to some extent.
Sure, but it makes sense to talk about it and make some decisions. At least, legally, you've declared what your wishes are. Like you said, you could change that, but maybe at least you've kind of shared your intention.
Right, and it's important to make sure that the person you name is someone who's going to carry out your wishes. If it's your intention that you don't want to be kept alive unnecessarily, you want to make sure that you appoint someone who is comfortable making that decision. If you have a family member that for religious, ethical, whatever philosophical reasons would never make that decision on your behalf, you don't want to appoint that person.
So what you're saying is most states, but they need to take.
And we do. We have a lot of clients that have winter residence in Florida, and we will do Florida forms for them.
Okay.
So they have Florida forms with their doctors down there. They have New York forms with their doctors here. I always tell clients too that if they do leave New York and move to Colorado or California or Florida, they should check with local counsel to make sure that what they have is appropriate for their new jurisdiction.
Sure, you're right, because it could be different, and then it
Right.
costs more money. You're thinking you're all set, but really you're not.
Right,
So,
right.
so bottom line is, people should take a look at their estates and see if the value is greater than the new amounts with New York State. That they ought to talk to their estate planning attorney and just review anyway. It's good to do that
It's good to-
regular
yep.
basis, and then the power of attorney, reviewing that, and healthcare proxy.
Right.
Anything else that we want to part with?
I think we covered it pretty well.
Great. Thank you so much, Phil. I really
Thank you.
appreciate
I
it.
appreciate it.
Appreciate your knowledge and sharing that with our viewers today.
Thank you.
And thank you for joining us. I'm Nannette Nocon, and it's About Money. Until next time.